Hello to my Law and Society class. Welcome to week 5. We have this week and next week, and then your summer session 1 course in Law and Society ends. It's been a quick summer session. It always is. It seems even quicker, I think, because we're not in the classroom. So I want to talk about a few things this week just to go over some of the finer points of what we've been studying. I want to remind you, last week you handed in your second assignment, the critical thinking. On the abortion issue, you were to answer 2 questions in the critical thinking portion at the end of that issue's cases. And it asked, is this, meaning the abortion issue, a legal or a political debate? And I just want to address that for a moment. So the abortion issue really expands over lots of different types of debates. First of all, there's a religious debate that some churches are against abortion on without any exceptions. And they petition, they march, they protest. For others, they feel it's a legal right, a constitutional right. They abide by Roe v. Wade and the ways it has been adjusted and tweaked over the decades. And of course, anything that brings this much passion and deals with morality and religion and law and society, whether it's prayer in schools, whether it's abortion, whether it's gun control, the death penalty, all of these things become not only legal issues, but they also become political issues. And when I say political, candidates, whether they are local candidates, mayors and governors, or whether they are running for Congress or the presidency, they are asked continually about the abortion issue. Even though Roe v. Wade called it a constitutional right in 1973, almost 50 years ago, we are still debating it from the legal aspect of how the laws have changed over the years, and the political aspects. Every single time there is a vacancy on the United States Supreme Court, the candidate that is nominated by the President of the United States, whoever the president is at the time of the vacancy, is asked over and over. The number one question is on Roe v. Wade. Asking, will you follow it as settled law, as precedent, or are you looking to overturn it? The other question that was in the critical thinking: do you think it's possible for judges to fairly rule based on the law regarding such a highly charged emotional and moral issue? So here's what I want to point out about that particular question. Do you think it's possible for judges to fairly rule? When someone becomes a judge, whether it is a local judge or a U.S. Supreme Court judge, they take an oath, and that oath states that they will protect and defend the United States Constitution. And the precedent decided by the U.S. Supreme Court on any case, including Roe v. Wade, becomes case law and recognizes a woman's right to choose within very strict parameters as a constitutionally protected right. When the court believes, when they are hearing cases, it is not up to them to impose their personal or moral view on a particular issue. It is up to them to decide under what circumstances do they think that this issue comes under the U.S. Constitution, and whether they agree with it or not. If it is a constitutional right, it is to be protected and defended by them. Judges have to decide cases all the time that they don't agree with, but they have to decide those cases based on the interpretation of the United States Constitution. So if you haven't taken constitutional law, I'd like to just spend a few minutes talking about the doctrines that we use when we describe how the Constitution is interpreted. So first of all, we have the doctrine of original intent. Under the doctrine of original intent, those people, even today, believe that the way the Constitution should be interpreted in the cases before the court is for those judges hearing the cases to ask themselves, how would the framers of the Constitution decide this case? Now, the Constitution was ratified in 1789, and the Bill of Rights, the first 10 amendments, were ratified 2 years later in 1791. So people who believe in the doctrine of original intent are basically trying to figure out how the framers who lived in the 1780s and 90s would decide the issues before the courts today. That's not an easy feat. That's not going to be easy to do. And the doctrine of original intent, trying to decide what the original writers or framers meant, is looked at as a conservative approach to constitutional interpretation, because people who believe in the doctrine of original intent believe that we should not change the Constitution unless it's absolutely necessary. That's why we say it's a conservative doctrine. We're not talking about politically conservative. We're saying that those believers don't want to change the document and want to interpret it as they believe the framers would interpret it. Now, the flip side of that is the doctrine of the living, flexible Constitution. Those who believe in the doctrine of the living, flexible Constitution believe that we should interpret the Constitution in the cases that come before the courts today in light of today, modern times. Certainly there are cases before the court every day that the framers of the Constitution never even envisioned. I mean, think about things having to do with computers and the World Wide Web. Think about things having to do with pornography, or so many issues. The LGBTQ population. We just had the U.S. Supreme Court today, today, hand down a decision in which that court said that the rights of those who either are gay, are lesbian, are even trans, their rights cannot be discriminated in the workplace because of that. And they're now saying that the 1964 Civil Rights Act that originated with the color, the creed, the religion, and national origin has expanded and has constitutional protections for that group. And so that would be the use of the living, flexible Constitution as opposed to the doctrine of original intent, because at the time that the Constitution was ratified in the 1780s and 90s, homosexuality was a crime. And so those are the kinds of balancing that you have to do. So the doctrine of the living, flexible Constitution is thought of as a broader or a more liberal approach to constitutional interpretation. So when we talk about a more conservative approach, we mean narrower, slow to change, don't want to make broad sweeping decisions. When we talk about the doctrine of the living, flexible Constitution, we are looking at cases before the court today in light of society and the beliefs and laws of society today, not in the 1700s. And so that's the balancing act. And so every judge, every day, is faced with the answer to that question. And the right answer is their job is to protect and defend the Constitution and not impose their personal views on the cases that come before them. Now, the reality of it is that they are human, and that if they feel very strongly about a particular issue, I am certain that it really challenges them on how they should answer it. And we have seen outside pressure on judges and politicians, especially with the abortion issue. The Catholic Church has excommunicated, kicked members of their religion out, ostracized them if they in some way contribute to keeping abortion legal or constitutional or expanding the rights under it. So when we talk about law and society, judges have a job, and they're not put there to impose their own personal moral views. But on the other hand, we are talking about human beings who have to keep in mind what their oath is and that their job is to interpret the Constitution. Okay, so that's just talking about the abortion issue. So this week and last week, we are getting into the death penalty. And the death penalty and the issue surrounding capital punishment. One of the questions that we ask all the time, just generally with the death penalty, is, did the framers of the Constitution believe that the death penalty was cruel and unusual punishment under the Eighth Amendment? And the answer to that is clearly no. They did not believe that the death penalty was cruel and unusual punishment. And how do we know that? Because they continued to use the death penalty in certain very heinous criminal cases, even after the Eighth Amendment was ratified to the United States Constitution. Last week I spoke to you in my taped lecture about the history of the death penalty and that period of time in the 1970s where the U.S. Supreme Court had a moratorium and believed it was cruel and unusual punishment. I think that when we talk more specifically about juveniles, the issue before us in this issue specifically is, does the cruel and unusual punishment clause of the Eighth Amendment prevent the imposition of the death penalty on juveniles? Well, until the Roper case, it was up to states. But since the Roper case, Roper versus Simmons, the United States Supreme Court has said it is cruel and unusual punishment, and that states can no longer give someone who committed a heinous crime before they turned 18. It doesn't matter how old they are when they get tried. It's how old were you when you committed the crime. No longer can they get the death penalty. Now, that doesn't mean they're not held responsible for the crimes they commit. They are held responsible, and they can get severe penalties. However, the penalty one option off the table, not a possibility any longer, found to be unconstitutional, is the death penalty. Now, let me just explain. I wouldn't get all upset or riled up about it, because remember, even before this decision, we still had a couple or a dozen or more states that didn't allow the death penalty for anyone if they committed a state crime. And so this, and at the time that Roper versus Simmons was decided, several states that had the death penalty for adults had stopped using it for anyone under the age of 18. And in fact, I want to bring up another case on this issue. In 2012, the U.S. Supreme Court decided the case of Miller versus Alabama. And in Miller versus Alabama, one of the things, or the main issue that they were faced with, is, can a person who's under the age of 18 when they commit a heinous crime, can they be given a mandatory life without parole sentence? Okay, sorry about that. Someone was at my door. We had a fence put in today, and they were coming by to check out the yard. All right, so what I was talking about, I just want to go over it one more time, is that the U.S. Supreme Court in 2012, in the case of Miller versus Alabama, not only has said since Roper that juveniles can no longer be sentenced to death if they were a juvenile when they committed the crime, but they have also now said that juveniles should not be sentenced to mandatory life sentences without parole. Now, let me just say, this is very specific. The idea behind this in the Miller case is that the courts believe that based on a person's age, sentencing them to a mandatory sentence of life without the possibility of parole would be cruel and unusual. It doesn't mean that a person who commits a crime can't serve their entire life in prison, because the mandatory word is what changes it. If states sentence someone who committed a crime when they were a juvenile to life in prison without parole, they can't make it mandatory, which means there has to be some review process. And some states get around this in a very sneaky way by saying that they're going to holding a hearing, and then always deciding, no, they're going to stay in for life, So let me go through a few things on this issue. Number one is that no longer, since Roper versus Simmons, anywhere in the United States can a person who was under 18 at the time they committed a heinous crime be given the death penalty, okay, no matter what. And let me just for a minute go over that. The reason for that is that when we look to other countries around the world and we look to neuroscience, the study of the brain, it has been adopted and believed medically and scientifically now that the human brain does not fully form until sometime after 18. Some studies show that they believe that the human brain is fully formed around somewhere between 23 and 25 years old, but clearly all scientists believe that it is after 18. It doesn't mean that the human brain is not capable when you are a juvenile of understanding wrong and right. However, because of that, the last thing that forms and matures in the human brain is impulse control. And so it is not an excuse, but it's an explanation of why some juveniles and some people in their late teens and early 20s are committing these crimes impulsively. Okay, so no juveniles can get the death penalty. Before Roper versus Simmons, we had the Atkins case. The Atkins case dealt with the issue of mental retardation. In this country, when we talk about this issue, can a person who's mentally retarded be sentenced to the death penalty? Be clear, we are not talking about someone who is so severely mentally impaired that they don't understand the difference between right and wrong. We are talking about the IQ test and the IQ scale, the intelligence quotient testing. Anyone who has an IQ test and tests 70 or above, and some people test way into the 100s, that person is in the normal range. Anyone testing in an IQ test below 70 has some form of mental retardation. Now think of what that word retardation means, held back. It means that for some reason, it could be many reasons. It could be something that happened at birth where their brain didn't get enough oxygen. It could be some accident. It could be anything. But we are talking about people who know right from wrong, who may not even be thought of as mentally retarded, but in fact, under an IQ test are. Anyone who tests below under a 70 on an IQ test would fall into the category of having some form of mental retardation. They could be charged with a serious crime. They could get life in prison. They might get life in prison without parole if they're not a juvenile when they commit the crime. But they cannot get the death penalty. And again, there's a correlation, there's a connection in the reasoning between persons who suffer from mental retardation and juveniles. With juveniles who commit these serious crimes, we say that their brain has not yet fully formed. It will fully form. They should have impulse control as they get older and their brain matures. However, with those adults who suffer from some form of mental retardation measured by the IQ test, they will never have a fully developed brain. And since the last thing to develop is impulse control, we use almost the same argument why those who suffer from mental retardation cannot receive the death penalty in the United States, and those who are juveniles when they commit a serious crime cannot receive the death penalty. They can both be tried, charged, and they can receive serious time in prison, maybe most or all of their life. And the added thing is the mandatory life sentences of life without parole can no longer be given to juveniles. They may get life without the possibility of parole, but it requires that there be some form of review to see if they've been rehabilitated while they've been in the system. Okay, so the death penalty and the history of the death penalty and how it's treated in the courts is changing, because we can see, 2005, 2012, all of these years, in the last 20 years, we have seen substantial changes in the interpretation of the death penalty. And once again, when we look at which countries we are in a group with who use the death penalty still and use it more than any other countries, it's countries that we look at often either as not providing human rights to their citizens, or we look at them as barbaric and uncivilized. And as a result of that, we need to ask ourselves, has the time come for us to move away from the use of the death penalty? Last thing on the death penalty, I want to point out that it is more expensive to sentence someone to death today than it is to sentence them to life in prison without parole. And the reason for that is when they're sentenced to the death penalty, it's a mandatory appeal, and those appeals can take upwards of 20 years from the time they're convicted and sentenced before all the appeals are expired and exhausted, and we get the final decision that yes, they can be put to death, or no, they can't. And so that's a very expensive process. And by the way, courts have no time limits on how long they take to decide these death penalty appeals. However, once they decide, the defendant has 20 days to file the next appeal if they have one in a higher court, and a higher court trying to get all the way to the U.S. Supreme Court. Okay, so that is the death penalty. I just want to end this by saying that what we're going to on Thursday start to think about, and maybe tomorrow or today in the email that I send you on Tuesday and Thursday of this week, is we're going to start looking at what's happening in our country. We're going to talk about, or we're going to get notes and discuss the COVID-19, how it has substantially changed law and society for us, both personally and as a full society and a country and the world. And so we're going to spend this part of this week and early next week. Next Tuesday, you will be getting your final exam that will be due on our last night of class, which is 2 days after that, on Thursday, June 25th. When I give you assignments, please be sure you get the assignments in on time, especially that final exam, because that final exam, we only have a couple of days to get in the final grades for the summer session 1 classes. It is imperative that you, with the assignments you get, you do them and you get them to me on time. Okay, so looking forward to this week. I'll be sending you notes on death penalty, and we'll be moving on from there and looking at COVID-19 through the lens of law and society. Have a great week, and we're getting near the end of our summer session. I hope that you have gotten a lot out of this and have some even better critical thinking skills than you had when you started this course. All right, take care, and I will see you again next week.